Is this Mr. Stone?
No, I'm not Stone. No,
What's
Well,
your
what's
last
your
name?
name?
mine Davis.
Melvin Davis is here today after failing to appear before referee Bradfield on February 10th, 2023. Bond is currently set at $500. This is the first bench warrant. He reports that he is employed at Larson Precision Paint. Last payment made on this account was in April of 2023. Friend of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on August 2nd, 2023 at 8:45 a.m. before this court.
Mr. Davis, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. The purpose of this hearing is to set a bond that would assure your tenants at the next hearing on August 2nd, 2023 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
I believe so. I haven't spoken to nobody, and I know like I got people with money and everything. Like I didn't even know I had old money in child support. Otherwise, that would have been taken care of.
Okay. Well, what I'm going to do is you are working. Go ahead.
I got money taken out of my taxes for the child support, so I figured when I got this, it tripped me out because I know they took money out of my taxes to pay for this. Like I don't get why I'm this whole situation.
Well, what happens, it takes time to get that. So they might have taken it, but the front of the court still may not have that money. Sometimes it takes months for them to get that. So that's why. What I'm going to do is I'm going to reduce, it's your first bench warrant, so I'm going to reduce your bond in hopes that you could be released. I'm going to set your bond in the amount of $100.
I appreciate it. Like
what?
So I appreciate it.
Okay. You post that, you'll be able to get released. Do you have any questions, sir?
No, that'd be it.
Okay, thank you.
Failing to
You're
appear
excused. Have a
before
good
referee
day.
Courteau on February 24th, 2022. Bond is currently set at $1,840. This is the second bench warrant. He reports that he is employed at Friends and Company. Last payment made on this account was in November of 2022. Friend of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on August 2nd, 2023 at 8:45 a.m. before this court.
Okay, thank you. Mr. Edmonds, you're before the court charged with civil contempt of court due to your failure to appear at a prior hearing as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on August 2nd, 2023 at 8:45 a.m. Are you able to post a bond, sir?
Probably not, sir.
Okay. Well, it is your second bench warrant, so that's not substantial, but you haven't made a payment since November. Are you still working at Friends?
Yes, sir. And I don't know why they quit taking payments.
Okay. Well, if they should ever stop taking payments, you need to do it voluntarily because that means you're not paying if they're not taking it out.
Yes, sir.
What I'm going to do is I'm going to reduce your bond in hopes that you could be released. I'm going to set your bond in the amount of $200. If you're able to post that, you'd be able to be released. Do you have any questions?
044023.
Okay, thank you. You're excused, sir. Have a good day.
In each of these matters, Mr. Stone is here today after failing to appear before this court on October 19th, 2022. In the first case, bond is currently set at $1,062. In the second case, bond is currently $500. This is the fifth bench warrant in each case. He reports no employment. Last payment made on these accounts was in August of 2022. For the record, that was a $200 bond forfeiture in each case. Friend of the court recommends that reasonable bonds be set in these matters and they be scheduled for hearing on August 2nd, 2023 at 8:00 a.m. before this court.
Mr. Stone, you're before the court charged with civil contempt of court as a result of your failure to appear at a prior hearing, as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on August 2nd, 2023 at 8:00 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, sir, not right now. Actually, I lost my job the last one I had for doing that freight hauler when I was just incarcerated, and I had caught COVID the last time I was in here. That's why I ended up getting sick and losing the job. But I be with the kids all the time. I just ain't had no good job to be able to pay it. I usually pay it. I like paying for my kids. I don't mind.
Okay. Well, it is your fifth bench warrant and you haven't paid in
Lost
approximately,
address,
well,
I'm sorry.
over a year. What, sir?
It was lost the address. I'm sorry about that. I didn't get a chance to get that address in. It was change
Okay.
of address.
You've got to get your change of address in or you won't get notice.
Yes, sir. I know. I got it in now. 211 224.
Okay. Well, what I'm going to do is I'm going to reduce your bond in hopes that you could be released pending that hearing. In the 07 case, I'm going to set your bond in the amount of $200. In the 04 case, I'll set your bond in the amount of $100. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay, thank you, sir. You have a good day.
Plaintiff is
Yes, sir.
attending via telephone.
Okay. This is a time and place set for the scheduling conference. We had previously been before the court on a scheduling conference on June 21st, 2023, at which time the plaintiff did not appear. And we advised the defendant to file a counterclaim or counter complaint so that we could proceed. The the defendant has done so. I guess I'll ask Mr. Ruger, why didn't you appear on the June 21st date?
I was having trouble getting my mail. I was unaware.
Okay. Well, make sure that you get that worked out because there are going to be other things that you're going to receive from the court. And if you miss those, it could have substantial consequences to you if you don't appear. Okay.
Absolutely.
Mr. Ruger, I'll ask you first. In the scheduling conference, we try to put in place various dates to, again, make the case proceed in an orderly fashion. And first, I'll ask you, what issues do you believe to be in dispute in this case?
I think I should have the children at the moment.
Okay. And ma'am, I take it that you don't agree with that.
No, I do not, sir.
Okay. So the court will put down that there's custody, parenting time and support at issue in the case. Is there any property disputes or spousal support disputes in the case? Sir, what are your thoughts?
No.
Okay. And Ms. Mitchell, I'm sorry, Ms. Ruger, what are your thoughts? Do you believe that those issues are in dispute as well?
No, sir.
Okay. Right. There is a process in the case, it's called the discovery, whereby you can acquire information from the other side, and that you can do it through interrogatories, which are requests of the other side. You submit questions that they have to sign under oath, and there's a request for production of documents, so the other side would have to present documents as well, if in fact they are requested. You could also take depositions. Sir, do you anticipate that you're going to do any discovery in the case?
I don't anticipate.
Okay. Ma'am, how about you?
No, sir.
Okay. I will give you until September 1st, only in the event that you choose to do so. That'll give you sufficient time. Plus, what it does, it'll set the matter for mediation in September. And the reason I do it is because your chances are you're not going to get to a mediator in any time sooner because they are that busy. So you have the right to pursue discovery if you wish to do so. I'll send the matter to mediation. That is a attorney mediator that will meet with you to again try to come to resolution in the case. There is a expense to that, and you'll have to pay for that prior to the mediation. And I'm setting the mediation for September. I'll ask you, sir, is there anyone that you would recommend as the mediator?
Not that I can think of.
Okay. And ma'am, how about you?
I do not, sir.
Okay. Then what will happen is the mediation clerk will randomly assign a mediator in the case, and that person will contact you, give you information, et cetera. And then you'll need to contact that individual and set up a date and time in September that you can meet with the mediator for purposes of scheduling that. Okay. The court will set October 9, 2023 at 1:30 p.m. as the settlement conference date. And that date when we get back, and if we're not settled, what we will do is then have to set the matter for trial at that particular point. I guess I'll ask Mr. Ruger, do you have any questions in this matter?
No, Your Honor.
Okay. And Ms. Ruger, do you have any questions?
No, I do not, sir.
Okay. We will send this out to you. You should get it within the next few days, or at least within a week. If you, in fact, when you get that, I would tell you pay attention, because there are dates in that order of times that you must exchange information or witness list or things of that particular nature. And property division charts, which you said there's not a property issue, so that shouldn't be a problem. But if you're going to file anything of that nature, you need to file it by a specific date, by your mediation date. And if you don't, there are consequences. So if you didn't file a witness list at the time you get to trial, you wouldn't be able to, in fact, call that person as a witness. So I'm just advising you that, so you make sure that that happens. Good morning to both of you, and I'll state this matter is before the court for a scheduling conference, and a scheduling conference is where we attempt to discern if there are any issues and disputes between the parties, and if so, we'll put in place a scheduling order so that the case progresses in an orderly fashion, and we'll set dates for various things to occur. I'll go to you first, Mr. Rodriguez, because you are the plaintiff. Are there any disputes that you're aware of in this case?
No, Your Honor. I think we've agreed on pretty much everything. I did actually submit a marital settlement agreement and turned that into the front of the court.
Okay. Ms. Rodriguez, is that your understanding that you don't have any issues in dispute?
No,
No, that's not your.
I mean, I agree what he said.
Oh, okay. Well, what I'm going to do is I'm not going to put in place a scheduling order, because as part of the scheduling order, we would set the matter for mediation with an attorney mediator. There's a cost involved with that. And if the two of you are able to come to resolution, I don't want you to incur any cost at this particular point. So we won't put in place an order at this time. What we'll do is just simply, sir, what you're going to have to do in this matter is you had a settlement agreement, but what you're going to have to do is you're going to have to prepare a judgment of divorce, a uniform child support order, and a judgment information form, those 3 documents. And you'll have to submit those to the front of the court for their approval.
Kayla Lovely versus Dustin Lovely.
Okay, good afternoon to all of you. Time and place set for the evidentiary hearing in this matter, so I'll go to
That's a rope.
what evidentiary hearing on Rolla.
Oh, okay.
So what we'll do is we're going to take some testimony from all of you in this matter. We'll go first. I'll give you opportunity. You have a right to make an opening statement if you wish to do so. Ms. Lovely, do you wish to make a opening statement?
No.
Okay. Mr. Lovely?
No.
Okay. Mr. Wilder, or is it Wild or Wild?
It's Wild.
Just Wild. Okay. Do you wish to make an opening statement?
We lost.
Looks like we lost Mr. Lovely from, oh, there he is. Mr. Wild, did you wish to make an opening statement?
No.
Okay. Then we'll go back to Ms. Lovely. Ms. Lovely, we're going to take some testimony from you. And
Okay.
what we'll do is, okay, trying to find get your file, pull that up. You filed a motion to determine the child was born out of wedlock, and that's Harley, correct?
Yes.
Okay. And Harley is 1 year old?
Yep.
Okay. And I don't have the date of birth, so if you could give me that, that would help.
June 7th, 2022.
Okay. So that would put the date of conception sometime in approximately September of 2021. Is that correct?
Yes, sir.
Okay. And At the time of conception, were you engaged in any sexual relations with Mr. Lovely?
No.
And when was then the last time before the September date? When would have been the last time that you believe that you had engaged in any sexual relations with the defendant?
May of 2021.
Well, over approximately a year and a half before the date of conception, correct?
It'd be the same year, but
Oh,
months earlier.
no, you said May of 2021 was the last date, but the child wasn't born until June of 2022. I see. Okay. I was the one that messed up the dates. I'm sorry. Okay, so approximately 11 months earlier.
I think
Nope.
so.
13
It might be
13
9.
Approximately 13 months, correct?
Let's see, May.
May of 21 to June of 22?
I think that would be 4 months, sir.
Okay, we must have the dates wrong then. You said
Because I
Harley
can see.
was
sorry, go ahead.
born in June of 22,
Yes.
and the last date you had sexual relations was May of 21.
Yes.
That's
I'm
13.
saying she was conceived in September of 2021.
Okay. But I'm going from the date of birth at this point. So it's approximately
Gotcha.
13 months. Child was born from the last time you engaged in sexual relations. Is that correct?
Yes.
Okay. Well, now you know why judges do what they do, that we're not math whizzes, so.
Right. I get it.
Okay. And in this particular matter, tell me, has Mr. Wild, has he, in fact, affirmed to you that, in fact, he is the biological father of Harley?
Yes. Me, Dustin, and Michael all agreed on that. Michael has been living with me since June of 2021.
Okay. Okay. And in this particular matter, has Mr. Lovely at any point engaged in a relationship with the child that would be typical of a child-parent relationship?
No.
And you say that Mr. Wild has, so has Mr. Wild carried on a relationship with Harley typical to a parent-child relationship?
Yes. And he does support her like financially as well for like different things she needs, like diapers and stuff of that matter.
Okay. Anything else, ma'am, that you would like me to be aware of?
You did order the DNA testing in December of 2022, I believe. And I did file those as well.
Okay, good. And the court is looking at that. That is a DNA test report signed by Michael L. Brand, PhD, dated 12/27/2022 in this matter.
Yes.
Are you offering that at this time as an exhibit, ma'am?
Yes.
I didn't hear you. I'm sorry. Okay.
Yes.
The court will admit the DNA test report in this matter as plaintiff's exhibit 1. Mr. Lovely, do you have any questions of the plaintiff?
No.
Okay. Mr. Wild, do you have any questions of the plaintiff? Okay. Well, I'll ask you at this time, Mr. Lovely, you've heard the testimony of Miss Lovely in this matter, and is that consistent with your understanding of what happened in this particular case?
Yes.
Okay. And do you agree with all the statements that she made as it relates to last time you would have engaged in sexual relations with her?
Yes.
And as it relates to the rest of her testimony, do you agree with that as well? Wild,
Yes.
do you have, excuse me, Miss Lovely, do you have any questions for Mr. Wild?
No.
And Mr. Lovely, do you have any questions for Mr. Wild?
No.
Okay. Mr. Wild, I'll have some questions for you at this time. Likewise, you've heard the testimony of both of the parties in this case. And is your understanding of the testimony correct and accurate? Would you explain
Yeah.
what your relationship is with Harley?
I am her biological father.
Oh, I meant as far as day to day, you know, what do you do? What kind of things do you
Oh.
engage in? Those types of things.
Well, when she wakes up, I help Kayla take care of her. You know, I help her change her, find her clothes if we're going out, and I feed her and just interact with her mainly all day.